Hi Marie. So today we're going to be talking about employment law. The first thing that I was quite interested to know in terms of employment law issues that you're aware of.
So there's lots of different things that can go wrong in the workplace. Obviously people spend a lot of time at work. So aside from family problems, employment's probably the second biggest. We tend to see employment problems arising mainly as sort of grievances in the workplace. So people will feel aggrieved originally about something that's happened to them, and that might be mostly that they feel they've been treated unfairly in some way, so there's a sense of injustice there.
Sure.
Or something like that. And then sometimes they try to sort things out informally and it doesn't work. So then we tend to see the problems escalating and mushrooming by grievance procedures and processes that are sometimes contained in a staff handbook through the Human Resources Department or a line manager if there is no Human Resources Department. So I would say generally as an overview, it's unfairness. People tend to come to us or identify issues initially as just being unfair.
Yeah, and when something feels instinctively unfair, then that's the point perhaps at which they think, actually, is this serious? Do I need to talk to somebody?
That's right, and initially you get sort of a 50-50 split with people who have problems at work. So sort of 50% will tend to explore things informally or go to human resources or look for a staff handbook or a policy about, well, what's happening to me and is there a policy in the workplace about it? And then there's another 50% who will immediately pick up the phone to a solicitor or their union representative, if they've got a union representative, and look to actually identify with assistance what the problem could be and how to resolve it. So both.
And that can depend, I guess, on the organisation as well, and the type of workplace, the size of it, the types of role that the person's doing as well.
Yeah,
perhaps.
totally.
Yeah.
I mean, obviously in the UK, there's so many businesses of different sizes, and in the legislation for employment law, all businesses need to act reasonably in light of the size and resources of the business. Yeah. So, somebody who's working in a high street store maybe that's family owned wouldn't be expected to be dealt with in a way that somebody at ICI or a big major employer, Amazon, would be dealt with. But still, it's got to be reasonable. In some companies, they've got a huge human resources team. In some companies, they might have a HR or human resources business partner. And in the smaller businesses, it might just be your line manager or the owner of the business who tries to sort things out. So it really is individual in every case.
We're going to talk about some of the specific issues that can happen in a bit. But in terms of sort of general advice, if someone thinks, okay, this isn't right, something's going wrong for me here, what options are available to get that first initial steer on what to do?
Okay, so in terms of in the workplace, as I said, you'd probably go to your internal HR. If you don't feel comfortable doing that, that's when some individuals reach out for support from, for example, the Citizens Advice Bureau, if they're available and have appointment times, Law Centre Network, if there's a law centre in their area, or tend to go online to the ACAS website, which is free and is full of information about your rights, employment rights, how to address issues internally. What we tend to find in practice is that when people speak to us, mostly they've been through the entirety of Google and ACAS, and then eventually they'll pick up the phone, because ACAS is isn't not an advisory service, so it's sort of an impartial intermediary. And sometimes ACAS will point people in our direction as solicitors. And what they'll tend to do is ask for a free half hour or can I have an initial chat. And I think most solicitors who act in the area on behalf of claimants would probably have that initial conversation. It's also possible, if you're an individual, that you might be insured to get legal advice for employment matters. And not many people know this, but most people nowadays have home and contents insurance, for example, on the properties, or contents insurance if they're renting. And the policies tend to have family legal protection or legal expenses insurance cover. And what that does is it allows the insurer will have a team who can take initial calls, guide people through a process and see if actually there's anything there to explore. And then later down the line, if the worst came to the worst, that sometimes funds claims for individuals.
I had no idea about that either. That's so interesting to hear.
So the insurers, most of the big insurance companies will have panel solicitors that they use, and they'll be able to put the person in touch with a panel solicitor. But if you are an individual, you have complete freedom of choice. So if the the solicitor that you want to use is not on a panel, you can say to the insurer, I would quite like to use this person, and then that person will engage with the insurer, and the fees for any potential claims are then covered. What
is the scope, would you say, for people to almost do it entirely on their own as well at that point? So to think, right, I've got this awful situation, I've got a bit of information in, and I'm just going to go for it myself. What is the scope there? Is it a difficult thing? Is it too much for somebody to take on themselves, or what do you think about that?
I think it really depends. So obviously, the employment tribunal system originally was called industrial tribunal, and is still a forum where you can represent yourself as an individual, or you can go with a friend to represent you, or if you're in a union, you can get a union rep. So, but if you're on your own, you can put in a claim. It's free and it's online, and then you get the employer gets 28 days to respond, at which point you're in the system, and at that point you can represent yourself all the way through. So you can go to a hearing, you can do everything yourself if you need to.
Sure.
A really useful resource if you are representing yourself in the tribunal is ACAS, because they stay with you all the way through a claim and try to help negotiate some kind of settlement if that's possible between yourself and your employer. So it is supposed to be a layman's arena. What I tend to find in practice is that people are happy to put a claim in, they're happy to go to through the original process of looking at the response to a claim, but when it comes to the hearing itself, they tend to want to be represented, or at least get a steer as to whether the claim's viable and are they doing it right, that kind of thing.
Of course, exactly, and that's at those points they would reach out to you and other employment lawyers to say, right, I think I'm going to need a hand with this one.
Yes, exactly right,
Okay, brilliant. So in terms of, I suppose, the legal status, so you've got the employer on the one side, the employee on the other, obviously both, joining forces to do whatever the organisation is doing. What are the sort of the differences between the rights, would you say, between the rights of the employer and those of the employee? Is there much difference in terms of the law?
Well, no. As a relationship, as an employee in a business, there's mutual rights towards one another. The employer's got a right, and you've a duty towards you, and you've a duty towards them. It's what we call mutual trust and confidence. There's a duty of mutual trust and confidence between you both. There's a duty of care from the employer to the employee, and obviously in terms of how you're treated, an employer does have obligations, and they're set down in law, and also set down through case law, and as the courts have developed, additional measures to protect employees in certain circumstances.
You've got this situation, somebody may be quite new to an organisation, everything's going great hopefully at first, but maybe a couple of years in or so, things might start changing, or their experiences might be different. Do you think that there are, within sort of the early part of starting to work somewhere new, are there any things that you would say, right, from the perspective of somebody who's just started a job, maybe a year or so in, keep your eye on anything, keep your eye on, I don't know, your rights or the way that your HR team works? Anything top tips wise that you might suggest to somebody?
So I suppose top tips wise, when you start at a job, really what you should be getting is a contract of employment from day one. And something that sets out all the terms of your employment, or basically most of them, and then the rest of the terms should be contained in a staff handbook. So when you're first starting out, you should probably be looking at your contract, making sure you're happy with that, making sure your job role's what you think it's going to be, being really flexible and open with your employer, lots of communication, and also looking at the staff handbook and just making yourself aware of all the policies that might impact you as an employee. That's probably one of my top tips. And then, if there are any issues or the contract's not quite right, or, you can identify them at an early stage. What I would say in the first year of employment is that, in fact, in the first 2 years of employment, there isn't an automatic right to bring a claim for unfair dismissal on its own.
That's good to know.
It used to be that you had to work somewhere for 12 months to qualify to bring a claim if you were dismissed. So say I was employed by you, and after 1 1 year and 2 months you decided to let me go, but you didn't do it properly. In days gone by, I would have been able to challenge that.
Okay.
But in recent times, that period has extended to 2 years.
Right,
So in the first
okay.
2 years of employment, if we don't get along as employer and employee and you would like me to leave, then if it's just that we're not getting along and it's not worked out, there's not a lot of real scope for an individual to challenge that.
Right, okay.
As long as they receive their notice pay and holiday pay, it just becomes a contractual arrangement. So the magic time frame really is 2 years or above.
Okay, yeah.
And we do get lots of inquiries from people who still think it's a year.
Yes.
There's a lot of misconceptions about that. And also think that, you know, they just don't like their job or something's not been done quite right and they've got a lot of rights.
Okay.
And they don't. So unless it's an automatic unfair dismissal, which is things like whistleblowing, breaches of health and safety, really serious things, then under that 2 years, there's not really anywhere that we can go with the claim. So it's almost like a 2-year probationary period for most people now.
Yeah, absolutely. So actually, that's a nice move across to look at a few of sort of the big ticket issues that can happen, and unfortunately do happen to some people. So we mentioned discrimination there. In terms of a workplace, what would that look like? Do you think? What would you say would count as a case of discrimination in a workplace? Are there any sort of features of that you see time and time again?
Yes, so discrimination is a massive area. I would come back to my initial comments on this, which is where I say as soon as there's a perceived unfairness, that's how people sort of come to me originally, or they go to a solicitor and they'll say, it's just not fair.
Just doesn't feel like...
Something's not right, it's just not fair, I can't explain it, but, you know, this person has been promoted and we've got the same qualifications, or this person's had a pay increase, this person's been, you know, allowed to go on 16 away days or additional training and not me. Or in some circumstances it's, you know, I feel bullied, oppressed, and I think I can't explain why this particular thing is happening to me. Is it because? And what the law does is it defines 9 protected characteristics. Okay, so under the Equality Act, which is basically a big piece of law that covers all kinds of discrimination in lots of different areas, there are 9 protected characteristics, and the most common ones that we come across are things like disability, so people who are suffering with health, and that could be mental or physical health conditions, sex, and then race, religion or belief, marital status. So they're just a few of the 9. It's discrimination if something is I'm saying really generally here, if something is happening to you and you think it might be related to or because of one of those protected characteristics. So one of the other common misconceptions we get is, you know, I'm just not very happy, we don't get along. That in itself is probably not discrimination, but if there is an underlying reason for that and it's related to a protected characteristic, then it might be. So it's really key to identify what's happening, what kind of discrimination it might be, because there are different types of discrimination. It can be direct, because of, or it can be indirect. And that's always difficult to do, because indirect is, you know, I say you've got to be 6'9" to take the job. More men than women would be able to take the job. So it's not necessarily saying I don't want you, but overall it precludes you from applying for the role. That's a tricky one. And then in terms of disability, there are obligations. So if somebody is disabled, then you have to make reasonable adjustments. So there's just so many different types of claim. I think that's where people get caught up the most. They know it's unfair. There's all these different types of claims. They just can't pinpoint which area protects them. So that's where I feel that a solicitor adds more value. Yes,
absolutely. In terms of working out, well, actually, is it just me? I'm experiencing this, but should that be right that that's happening to me? Actually having that conversation with somebody, you know, an employment lawyer, for example. I guess that's part of that process, isn't it, to work out, well, actually this is or this isn't acceptable.
And sometimes the job, when you know, I take a lot of calls from individuals, and I've done 20 years qualified, so, you know, I've been doing it for 20 years and I've spoken to hundreds of people all over those 20 years. And most people start off saying to me, you know, I feel like I'm going a bit mad. You know, this should not be, you know, impacting on me the way it is. I'm sure there's something wrong.
Yeah.
And sometimes it's just a matter of a bit of counselling because actually the law doesn't help them. But then often if you talk to somebody for at least half an hour or more, you start to think, well, there might be something in there. And that's, I think, again, the value added is in speaking to somebody who can quickly pick out, well, actually, no, there isn't anything there, you just need to move on. Which sometimes helps people more than anything else.
Yeah, absolutely.
Or saying, actually, you have got, potentially discrimination claims there, which of course are very valuable in terms of compensation.
Of course.
Yeah.
So actually in the workplace, so if somebody is starting to experience those feelings and just thinking this isn't right, I'm not getting a fair deal here. Have you got any advice for somebody in that situation about perhaps as part of their journey to reach out to somebody for help? Is there information they could start collecting, or people they should be talking to at that organisation as well?
So I think the first thing we like to explore with people is, have you tried to resolve this informally first? So most disciplinary and grievance procedures, and that's another one of the areas I'm being disciplined, it's not fair, but most of these procedures have an informal resolution embedded in them first. So we normally say, have you tried to resolve informally? What steps have you taken? Have you talked to HR? If it's about your line manager, have you escalated above your line manager? And then we say, if you do feel that there's something awry, then try to keep records of what's happened, because you forget really easily when you're stressed. Keep a note of what's happening and when and what you've done and how you've tried to resolve. And just to come prepared with a lot of information. If you end up then not resolving internally and have to come and speak to us, it's always really helpful if there's a really clear, concise chronology, I suppose, of what's happened. Because those initial phone calls with people seeking advice tend to be people who are very upset. And it can be, difficult to establish what happened when, and how. And timescales in employment matters are really tight. Really tight. So, in a lot of the civil courts, you get 3 years or 6 years. In the tribunals, it's 3 months.
Good grief. Okay, so actually
12 weeks.
By the time people come to you, is it common that you're already very close to a cut-off point?
So that's, in terms of tips, I would say, if you can get the advice from ACAS or from the CAB or from the solicitor or wherever you seek it, reach out straight away, because the number of individuals that we do speak to have missed that deadline. So from being dismissed, it's 3 months less 1 day from the date that you were dismissed. And you've got to start what's called ACAS early conciliation first now. That's like a mandatory precursor to a claim. So if you've gone past internal things and you go on to claiming, you've got to go to ACAS first, and that might extend the deadline, but not by a lot. So it's really, it starts to get a bit complicated. And particularly with discrimination claims, I know we were talking about that, you tend to get 3 months from the date of the act that you're complaining about.
So actually not that much time in that way.
Bullied or harassed, and then you leave it a bit, and then it happens again, and then you leave it a bit. Every 3 months that passes, technically, there are ways to get round it, but arguably, those things could be out of time. So it's really important, the timings.
Exactly, and to start reaching out as soon as these kinds of situations start to occur. Absolutely. So in some situations, obviously, there's a formal approach when the person's been dismissed, for example. What's the difference between, there's obviously the term constructive dismissal and then an unfair dismissal? How do they sort of work together? Or are they totally separate things?
So totally separate. So this is really, this is something we get asked all the time. So people will say, I am being constructively dismissed. I have been constructively unfair dismissal. The difference is that an unfair dismissal is when somebody is actually dismissed by their employer. So that's the type of claim that you would bring. If we were working together and I dismissed you, you would bring an unfair dismissal if you thought it was unfair. If we were working together and I made your life so miserable that you felt you had no option but to leave, or I did a series of things that made it impossible for you to work there anymore and you left, that would be a constructive dismissal. So that's the difference. And there's also a difference in burdens of proof on that as well. So if I actually dismiss you and it's an unfair dismissal claim, me as the employer would have to prove that I had actually acted fairly in dismissing you. So everything's on me. Whereas if you leave and you resign, the burden is on you to prove that I, as your employer, acted so unreasonably,
Yeah.
there was no option but for you to leave. And you've got to show what they call a fundamental breach of contract.
Okay.
So sometimes
right.
it's things like not paying somebody and it's really obvious.
Yeah.
But one of the most common things for constructive dismissal is a breach of the term, which is implied into every contract, of mutual trust and confidence.
Okay.
And that might be bullying somebody to the point where
Right.
they just can't take anymore, for example, or
Yeah.
asking them to leave.
Yeah, absolutely. I mean, in both of those circumstances, have you got any advice for, you know, the employee who is perhaps thinking, listen, I can see where this is going now. I'm off. You know, I've been given notice, or I feel I've got no option but to leave myself. Again, in that sort of time period before they actually leave the organisation, what are there things that could be helpful to do in that window?
Yeah, really helpful. I mean, if you feel you've been dismissed, so if you've been dismissed and you work in notice, or if you've just been dismissed following a disciplinary procedure, you should always appeal. There should always be an appeal process as part of that process.
Yeah.
If you feel it's unfair, you should always consider an appeal and take advice on that. If you feel you're being constructively dismissed, I would encourage anybody before they resign to take advice. Yeah. That's one of the most common areas where people will come to us after the event.
Okay.
And we will have to say, well, this, you know, it may be, but it's a difficult claim to bring anyway.
Yeah.
And perhaps it, you know, things should have been left, or your claim's not got merit. So I would say don't leave before taking advice. But if you are dismissed, then always exercise your right to appeal.
Okay, interesting. So actually that's straight away, there are a few things, even in a sort of an unfortunate situation like that, you can still be doing proactive things.
Yeah.
Yeah, to collect evidence.
Yeah. And also, if you think you're going to be dismissed, or you think the relationship's broken down, it is possible to have an off-the-record conversation with your employer.
Yeah.
I mean, I would take advice if you were going to do that, but, you know, negotiated exits and mutually agreed exits are also quite common nowadays.
Yeah, okay. Well, with constructive dismissal, are there any overlaps or interplay with somebody's mental health at a particular time? So if somebody just generally is, you know, starting to experience issues themselves, and that potentially impacts the way that they're working or their relationships at work and things like that, do you see is there sort of a correlation there sometimes with a constructive dismissal case?
There can be a difference in
Depends
sort of
on
how things are
circumstances,
seen.
right?
Yeah. I mean, what I would say about anybody who's suffering with mental health, and we have seen more and more of that over the years actually, and actually coming out of COVID and the pandemic, you know, there's been quite an increase in people who have suffered mental health related issues, a variety, is that in some cases, if it's serious, quite serious and long term, a mental health issue can be a disability for the purposes of discrimination legislation.
Okay. Yeah.
So it doesn't have to be a disability in a sort of, you know, visible sense that somebody's using an aid or, you know, is deaf or something like that. But it can be that they've got a physical or mental issue which is affecting the health. If it's going to last 12 months or more, or might last 12 months or more, and if it has an impact which is quite substantial on what they do on a day-to-day basis, then they have got additional protections under the discrimination legislation.
Okay.
So if somebody is suffering with the mental health, what I would encourage them to do is to be open about it and to speak to their employer. And then a raft of various things can be put into place. Lots of employers have mental health first aiders who can deal with things, which is a qualification a lot of people do have nowadays. And it's a great qualification actually. If things do progress, then the employer needs to put in place reasonable adjustments, and that might just stop things from progressing to a legal level.
Okay, that's interesting. So even in those, you know, those kinds of situations, still things to think about in terms of getting support, and certainly communicating, you know, and talking quite openly if you can with your employer as well.
Yeah, I think communication is key. A lot of things escalate because the communication has been poor, or one party doesn't understand the other parties.
And as soon as it's gone and that, you know, that's broken down, it's
difficult.
Before you know it, there's a course of events.
It's difficult. I mean, I'm also a workplace mediator, so as well as being a solicitor dealing with the aftermath of issues, I tend to go in to companies and mediate between individuals. And the number of mediations I've been the last sort of 6 years where people have said, I didn't realise that's what you thought, or why didn't you tell me this earlier? And these things can be resolved really easily, and it is always communication. Emails are not great.
Yes. Yeah, they can be quite impersonal sometimes as well. Yeah, I think we've all had an email from someone you're like, are they having a go at me? I don't quite know. So how about in a situation of redundancy? So if there's been a change at an organisation and there are going to be roles that are no longer required, for example, and people are going through that process. Firstly, are there tips that you might have for people in those kinds of situations? And are there sometimes sort of legal issues around that as well that people need to be aware of?
Yeah, redundancy has been quite commonplace actually recently. It's an escalating area of advice. I think that's a sign of the times. But one of the most common inquiries we get about redundancy is, well, my job's still there. They still need people doing that job. I'm not redundant. So we always have to start with the basics in terms of tips for redundancy. I would say, first of all, if you're not sure, do take advice. But a redundancy in law is if part of your business is closing down, the whole of the business is closing down, or there's fewer people required to carry out that role.
Oh, right, okay.
So it's always the last one where people have a difficulty. So the best way to explain it, I suppose, is say you're working in a supermarket and there are 8 people behind the deli counter. You still need people behind the deli counter, but you only need 6. That's still a redundancy technically, because 2 people would need to go. So the role still exists. It's just that there is a redundancy situation because fewer people are needed. I think that's the best way. People tend to relate to that better than anything else. And if that is the case, then the employer has a duty to follow a fair process. And in redundancy, that's pretty straightforward. So if you're being made redundant, you need to find out, does it fit the criteria for redundancy? But then secondly, is your employer following a fair process? So that would involve selecting people fairly. So going back to my deli example, they can't just say, it's you, I don't like you. What they've got to do is put everybody in a pot and then choose people fairly according to objective criteria. So they can't say, you've got a health condition, you need to leave, or you're a woman, you need to, for example. They have to show that they've chosen the right people carefully. Then they have to consult with the individuals. So a couple of consultation meetings. And then only at the end of that, when they've explored other options, like, is there another job? What else can we do to avoid redundancy? How might this work? Should you be dismissed? So if you're looking at flashpoints, I would say, check to see if it is a legitimate redundancy first. Because some employers use the word redundancy when it's not. But secondly, always just look at the process and make sure that the process is fair.
Is there, for ACAS, for example, is there a source of help sort of on the day of being told, okay, you're at risk of redundancy? Are there people that you could quickly reach to, do you think, to say, actually, is this process right? Is this fair? Can they do this?
There are. So ACAS are great. You can pick the phone up to them almost at any time and get through to an advisor who will be able to just sort of say, this is the process. They won't generally comment whether it's right or wrong, but they can give you a good steer. But I would also say that on the ACAS website, and the government website, actually, there's lots of information. So YouGov, lots of information about redundancy, what's a fair redundancy, what will you be entitled to, what should be happening. So, it's readily available if you're computer savvy.
Yes, of course, a lot of things these days, isn't it? Can you tell us a bit about settlement agreements? And so, from the perspective of somebody who, maybe there's been an issue and that they're, working to a conclusion, at what point would a settlement be agreed potentially between the employer and the employee? What does that look like as a process?
Yeah, it's really interesting because settlement agreements are commonplace nowadays. So, for the benefit of people that don't know, a settlement agreement is like a way that an employer and an employee can agree terms to end the relationship. And if an employee signs a settlement agreement, what they're basically doing is waiving all of the rights to claim.
Oh, right, okay.
So it's a clean break in effect. So what would generally happen is a settlement agreement can be proposed by either party at any time. So sometimes it's at the end of a process. If the employer thinks there might be a claim, they might propose a settlement agreement instead. And sometimes an employee might say, look, in the constructive dismissal case, for example, I can't stand this any longer, maybe we can talk about terms of an exit.
Yeah.
So if you're thinking about settlement agreements, there's procedures you can go through. A lot of the conversations are off the record,
Right,
and that can be without prejudice or what's called a protected conversation.
Yeah.
So there's different things to look into there. But generally, the terms of any settlement agreement are pretty standard, and they'll include things like, you keep things confidential, don't make derogatory comments against one another.
Yeah.
There's an agreed reference 9 times out of 10. And then it sort of details the terms of the exit, and that might be your working notice or your not working notice. And there can be an ex gratia payment, which is basically a compensation payment to say, things haven't worked out. Off you go, here's a month's pay or a few months' pay, or it can be, sometimes it's 18 months' pay, sometimes it's 1 month's pay. It depends on the circumstances. So that's sort of, in a nutshell, the benefits of a settlement agreement. And then once it's signed, everybody just parts company.
Okay.
So it can be, sometimes employees that I've worked with have suggested it, and sometimes employers will say, here's a bit of extra. Sign here. If you do sign a settlement agreement, then you have to get advice from a relevant legal advisor.
Okay.
No, sorry, a relevant advisor, not legal. And that can be a solicitor or a trade union rep, somebody qualified. And the employer normally pays for that.
Yeah. Okay. Brilliant. So actually, I mean, on that point, so if somebody does reach out and thinks, okay, I do need some help with this, and they talk to you or somebody else that can provide that support. What does that look like? So what's the overview of that? So do you sort of have an initial meeting? Do you do it very over the phone? What can that look like?
So nowadays it looks however the person wants it to look. So we'd probably get an inquiry through, somebody saying this has been suggested, or I don't know what this means. And then we either have a telephone, Zoom, Teams, or in-person appointment with the person.
Yeah.
Generally the person will have the agreement. We sit down, run through the terms of the agreement with them, explain the effect of the agreement, that it's a waiver of claims, talk about whether it's a good deal.
Yeah.
Because, sometimes that's mostly what people are concerned about. Is it a good deal?
Yeah.
I don't want to waive all my rights if I've got, potentially a claim that's worth quite a lot of money.
Yeah.
So we talk about, is it good, is it bad? And then either the person will accept the terms and we get it signed up, or they can negotiate, depending on what they've said. You can go back and make a counter offer.
Yeah.
Or they can decide not to proceed with it. And walk away. I would say the most common approach is that people tend to make a counter offer if they're not happy, and then terms are agreed eventually.
Yeah.
I've only ever really had 2 that have not gone anywhere, and that's in 20 years. So normally there's quite a bit of give and take in these situations.
Yeah, that's brilliant. I think, Marie, that was all our questions today. So thank you so much. It's been really, really helpful. I've learned a lot, and thank you so much for your time.
Pleasure. Thank you.